Neha Gupta, come to the front door! Do it now!
Hands! Hands! Come out!
Contact.
On the ground. Come here.
We have carefully been following the case of Dr. Neha Gupta, the Oklahoma pediatrician accused of killing her 4-year-old daughter during a Florida vacation. The initial charge, first-degree murder, with prosecutors alleging she staged a drowning to cover up something far more sinister. Well, now, in a dramatic twist, that charge has been dropped. Gupta is instead facing aggravated manslaughter, a stunning legal shift that raises new questions about what really happened and whether prosecutors can prove their case at all. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. We have been following this heartbreaking case for weeks. The Oklahoma pediatrician, the mysterious death of her 4-year-old daughter in a Florida pool, and the shocking allegations that she staged a drowning to cover up something far darker. However, today, the story takes a dramatic turn. Why? Because prosecutors have suddenly dropped the first-degree murder charge. This is a seismic shift in a case that has already been full of twists from the beginning. We're talking about Dr. Neha Gupta. She faces now a lesser charge of aggravated manslaughter. That is a stunning downgrade that completely changes the legal landscape of this case. And here's what's new and what it means. So at a hearing on August 7th, prosecutors announced that they filed for a lesser charge, aggravated manslaughter of a child.
The charges at this time, Your Honor, the state has filed are aggravated manslaughter charges. And
all right, and you filed a motion for pretrial detention.
yes, sir.
We have written pleadings by counsel.
Yes, Judge.
Plea of not guilty is entered. We could go ahead and set this out for a sounding trial date in an AB week, please.
Gupta's defense attorney, Michael Myrer, responded to the development, telling local media, "Our position from day one has been that Dr. Gupta did not intentionally harm her child, that her child tragically got out of the locked door and fell into the pool accidentally. We believe that the Miami-Dade Sheriff's Office rushed to judgment, went out to Oklahoma with U.S. Marshals, arrested her with first-degree murder, and this confirms that the state attorney's office cannot prove that Dr. Gupta had at any point harmed her child intentionally." So if you're just now catching up to this case, let me walk you through everything that we've learned so far and why this is such a big shift. Because based on the arrest warrant, and that was released when she was initially charged with first-degree murder, we got a lot of details. Around 3:40 a.m. on June 27th, police responded to a 911 call at a rental home in El Portal, Florida. Dr. Gupta reported that her daughter had possibly drowned. First responders arrived. They were led to the backyard pool where they made a devastating discovery. The warrant reads, officers observed AT, hereinafter referred to as the deceased victim, unresponsive and submerged in the deep end of the swimming pool. MDFR personnel extracted the deceased victim from the pool and began cardiopulmonary resuscitation. MDFR transported the deceased victim to Jackson Memorial Hospital, where despite all life-saving measures, the victim was pronounced deceased at 4:28 a.m. Now, Gupta voluntarily gave a statement to investigators, and she apparently said that she and her daughter were asleep in the same bed, but then around 3:20 a.m., she woke up, realized her daughter was gone. She said the sliding glass door had somehow been opened, telling police the subject stated prior to sleeping she checked all the sliding glass doors at the residence. The subject stated she then observed the deceased victim submerged underwater within the swimming pool of the residence. The subject stated she attempted to remove the victim from the pool. However, she was unsuccessful due to the fact that she is unable to swim. The subject stated she attempted for approximately 10 minutes to assist the deceased victim before contacting emergency services. Investigators say the autopsy revealed something different and something very, very troubling. On June 29th, so 2 days later, a medical examiner with the Miami-Dade County performed an autopsy on Arya Talathi. And the findings seemingly contradicted Dr. Gupta's account. According to the warrant, quote, Dr. Tran advised that the deceased victim's lungs and stomach did not contain water and was considered dry. Dr. Tran also advised that based on these findings, she was able to rule out drowning as being a cause of death. Furthermore, Dr. Tran discovered cuts within the mouth and bruising within the cheeks of the deceased victim's face. Dr. Tran confirmed this type of trauma is not consistent with any life-saving efforts which were performed on the deceased victim by medical personnel. And maybe the most disturbing of all, in Dr. Tran's opinion, the deceased victim was deceased prior to being placed into the swimming pool. While the official cause and manner of death remains pending further studies, the doctor's preliminary findings are the injuries are consistent with asphyxiation by smothering. Now, initially, Gupta was charged under Florida statute 782.04, which is the unlawful killing of a human being when perpetrated from a premeditated design to effect the death of the person killed or any human being. Now, the aggravated manslaughter charge reads, a person who causes the death of any person under the age of 18 by culpable negligence commits aggravated manslaughter of a child, a felony of the first degree. So, does this make sense? I don't know. Let me bring on right now somebody who can maybe potentially make sense of what is going on here. Marian Braccia, director of the LLM and Trial Advocacy Program and practice professor of law at Temple Beasley School of Law, former prosecutor. Thank you so much for coming on. This is a change. I know that there can be disagreements between prosecutors and law enforcement about charges, but let's just get right into it. If you're having a medical examiner making that statement and now they've made it manslaughter, please try to make sense of this for me.
Jesse, this is, you use the word seismic shift, and I think that is the perfect description for this. There is a world of difference between a murder charge, a first-degree murder charge, and the aggravated manslaughter charge that this has been downgraded to. And to be perfectly honest, I do not envy a fact finder, either a judge or a juror, who's going to have to make a determination in this case, because it is a tough one. Is it a mistake? Could it be a mistake on the part of the medical examiner that the conclusion was wrong? Was it a miscommunication from what was communicated from the ME's office to law enforcement? Or could it be, hey, listen, we're not discounting what the medical examiner said. We're not contradicting what the medical examiner says. But unfortunately, we just can't prove a murder charge. I think any of those possibilities is a possible answer here. And I think that something that is most helpful for the defense is going to be this seeming inconsistency between what the medical examiner reported and found, especially concerning the fact that there was no water inside the lungs or inside the trachea of the decedent, which would tell us that her cause of death was drowning. So because the body, the internal organs where you would expect to see water damage as a result of a drowning, if there was no evidence of that really cuts against what we would think of as a negligent death, a negligent homicide, and would go much more in favor of an intentional killing of specific steps that were taken to end a human life, which would really be the foundation of the first-degree murder charge. So there is seemingly an inconsistency here between what the state's evidence would show from the medical examiner versus the charge that the prosecutors have opted to proceed with.
Hey, so I know many of you out there might be true crime fans, but is anyone in a business of some kind too? If so, let me ask you something. How much time do you think your business team is spending just in spreadsheets, chasing down receipts, trying to make sense of endless rows of bank statements? Yeah, probably too much, but that is where Odoo Accounting steps in. So Odoo gives users a clean, modern accounting dashboard that shows you exactly what you need. Your bank balances, your cash flow, your vendor bills, your customer invoices, all in one place. It's easy to use, it's easy to navigate, and for anyone managing their business accounting, it's invaluable. You want to know why Odoo is going to give your business a cutting edge? Well, Odoo uses smart AI with a 98% recognition rate to automatically generate invoices and vendor bills. So all you have to do is just review and validate. That's it. Their bank reconciliation, next level. Odoo connects with over 28,000 banks to automatically match your transactions with your financial records to give you pinpoint accuracy. There's no more guesswork. Need reports? Guess what? Odoo's got everything from your balance sheet to your cash flow statements, professionally formatted, instantly accessible. So if you've been doing all this accounting work manually, you can stop right now. Automate invoices, vendor bills, accounting workflow with Odoo today. Get a free 15-day trial today at odoo.com/sidebar accounting. And by the way, the autopsy also revealed that this little girl's stomach was empty. So this contradicts the defendant's account that they had dinner at 9 p.m. as she had suggested. That's significant. And yet again, you have a downgrading of a charge.
Right. And again, it's going to be up to the fact finder whether the defense or the prosecution opts for a jury trial or a judge trial. If this does proceed to a trial, it's really going to be up to the fact finder to sort out whose version of the events is more credible, whose version has the ring of truth, so to speak. And so if there is evidence from the defense regarding what time they had dinner or the circumstances of where or how they were asleep or where or how the decedent's body was found, that may cut against the credibility of the defense case or the defense version of the events. But while at the same token, we are, and when I say we, I mean the fact finder is going to have to parse out the inconsistencies that might be presented in the prosecution's case in chief, given the nature of the investigation, the inspection of the body, the medical examiner's report, and then ultimately the charge that the prosecutors are going to be arguing should be sustained by the fact finder. This is a tough one.
And just to clarify, what do you think the potential theory of manslaughter here is? Is that you were reckless, you left this sliding glass door open, your daughter walked out, perhaps, potentially, possibly, your actions to try to save her made it worse? Because I do, and tell me if I'm reading way too much into it, but I'm also taking her attorney's statement where they keep hitting upon the fact, we always said from the beginning, she did not intentionally harm her daughter. Now, they do say it was an accident, but they could have said that she didn't cause the death of her daughter. I wonder, again, I might be reading too much into it. I just don't know what they may or may not agree regarding her culpability in this situation. I think at the end of the day, we can all say, this girl should be alive, but the question becomes, why is she dead? So I'm trying to understand what the manslaughter theory could be.
I think the manslaughter theory gives the defense something of an out, so to speak. Of course, there is no burden on the defense to present any theory of the case. The entirety of the burden of proof lies with the prosecution to prove every element of every charge, even if there's just one charge remaining against the defense beyond a reasonable doubt. To answer your first question, that manslaughter charge, even the aggravated manslaughter, is commonly known as criminally negligent homicide, which means that it's causing the death of another person due to criminal negligence, which is a failure to exercise a reasonable standard of care. And it differs from voluntary manslaughter, which would be an intentional killing while in the heat of passion. You know, for instance, the classic example from our law textbooks is you walk in on your spouse in bed with someone else and your passions are so aroused or so invoked, inflamed that it is an intentional killing, but it's in the heat of the moment, in the heat of the passion. Whereas with this with this involuntary manslaughter charge, the claim would be that it was so in such gross disregard of human life or the reasonable steps that any reasonable person in this defendant's position would have taken to safeguard this child's life. So we see criminally negligent homicide charges sometimes in child endangerment cases, for instance, leaving a child unattended in a hot car on a hot day, leading to heat stroke or leading to death, or even in inadequate security cases where a business owner or a property owner could be responsible for the death of a tenant or a customer on their premises if there aren't adequate or reasonable security measures in place. So I can envision a world where the defense attorney has consistently used the phrase, she did not intentionally cause the death, in order to effect this downgrade to the manslaughter charge and get the first-degree homicide charge off the table, which certainly lessens the defendant's exposure to a criminal penalty. And at the same time, it gives them the ability to argue in their defense, listen, the prosecution story is inconsistent. They don't even know what happened because they have this medical examiner's report that says a smothering death or a non-drowning death. But meanwhile, here we are proceeding with an accidental death or an unintentional killing charge. So which one is it, members of the jury?
And something to note about this as well, first of all, the warrant notes that this little girl's cause and manner of death still remains pending further investigation. There was a statement from Ed Griffith, who is the Miami-Dade State Attorney spokesperson, said in a statement to the Miami Herald, quote, "Based on the evidence presently available to prosecutors, the degree felony charge of aggravated manslaughter of a child has been deemed as the appropriate criminal charge." Now, Gupta was arrested just days later, and this was captured on body cam video that was obtained by Law&Crime. U.S. Marshals, they executed a warrant at her Oklahoma home, and they found her hiding inside.
Police with a warrant! Open the door! Do it now! Come to the door!
Turn around. Last come up with breach. She just went back in the house. Breach. Oh.
Neha Gupta, come to the front door! Do it now! For U.S. Marshals, we have a warrant for your arrest! Come to the front door! Do it now!
Inside, they cleared the home room by room.
Let me give this closet. Clear the closet.
Clear.
Okay. Yes, it does kind of come back around, so just hold what you got there.
Partially open the door all the way down through the hallway.
Does that go out to the garage right there?
Yep.
Hey, we're gonna clear this garage, so back up a little bit, will you? I'm hungry. Okay. It's unlocked. Go ahead and open that and we'll maybe we'll clear this.
Nope. Okay, so we kind of remember what's on it, if it's a lock or something.
Still have contact with target. So you'll just start him to have come this way. Okay.
Hey, we're opening up these garage doors. Opening up the garage doors.
We're clear outside.
Shut down here.
And then finally,
Hands! Hands! Come out!
Contact!
On the ground. Come here.
Alright, stand up. Keep clearing the rest of this and get her out.
now court records show Gupta shared custody of Aria with her ex-husband, Dr. Saurabh Talathi. However, authorities discovered that he had no idea the child had even left Oklahoma. Quote, the subject shares custody of the deceased victim with her ex-husband, who did not travel with the subject and the deceased victim to Miami, Florida, and was unaware that the deceased victim had left the state of Oklahoma. According to Dr. Talathi, her ex-husband, there is an ongoing custody battle within the state of Oklahoma over the victim's care between himself and the subject. Now, Professor, how does that affect things? What kind of witness would he be at a trial?
I think the evidence of the divorce and of the custody dispute is going to be highly relevant in this case. It all goes to what we call the res geste, the story of the case, the background of the parties, the state of mind, perhaps even of the defendant. In the footage that you showed of the arrest, the fact even that the defendant left the jurisdiction and then was found hiding, I think the prosecution would be within their rights to argue that that is evidence of consciousness of guilt, that someone would absent themselves from the jurisdiction where this death occurred and then would be hiding, would be attempting to evade apprehension. That goes to the defendant's state of mind, perhaps revealing some consciousness of guilt. That would be the argument. And then, of course, the tension or any conflict between the parents regarding the custody of this child, again, is going to lend to the defendant's state of mind, what she was thinking, what her mental state was as she was caring for this child, and what, again, the prosecution might argue what alternatives this defendant was willing to pursue to change custody arrangements or ensure that the child wasn't in custody of her father.
Yeah, this custody battle had escalated just months earlier. You had a judge who awarded Dr. Talathi, the father here, temporary sole custody, citing medical interference. That ruling reads, the court finds as follows, that temporary sole custody is awarded to the petitioner. The court finds that an emergency exists and that the respondent will continue to interfere with medical treatment of the minor child. Now, it was also reported that Gupta was ordered to provide vaccination records and disclose her location, but there were concerns about her behavior that were already building. In April, Talathi petitioned for a court-ordered psychological evaluation, citing very troubling behavior. His filing described, quote, unreasonable positions on issues concerning the child, unusual mood swings, and erratic behavior raising concern for the safety of the minor child. Extreme conflict and defensiveness with almost all persons caring and providing insight for the minor child, to include family members of the child, medical providers, counselors, and experts involved in this litigation, that respondent continues to author false information to the minor child's medical providers regarding claims of domestic violence by the petitioner in a restraining order that has been previously denied by the court. Further asserted, the respondent has put the child's ability to receive medical treatment at risk due to her inappropriate behavior towards the child's providers. That respondent's behavior leads petitioner to believe that respondent has mental health issues that are not being treated. That an evaluation of respondent's mental health is crucial to ensure the safety of the minor child. Now, Professor, if this was still a murder charge, right, I could have seen a situation where they say her world was crashing down, she was behaving erratic, she was a danger to herself and her child, and she killed her daughter and staged the scene to make it look like an accident. Now this has changed. This is manslaughter. How do you think, if these are legitimate, credible findings of mental health, how does it work for the prosecution? How does it work for the defense?
So I think for the prosecution, I would anticipate that the prosecution will move pre-trial and give notice to the defense of their intent to use some evidence or some testimony from those family court hearings and those family court findings, notably the failure to provide medical treatment or to comply with medically necessary treatment for the child or vaccinations for the child. So all of that would be considered what we call, under the rules of evidence, other act evidence. And of course, the prosecution has to give the defense notice of their intent to use that evidence. But again, it goes to show the evolution of this relationship and the evolution of the state of mind of the defendant. Since we are still on a manslaughter charge and the charge is essentially an unintentional killing, I think that there is evidence from the family court proceedings regarding medical treatment, regarding the allegations from the decedent's father, to say this was someone who was negligent in her care of this child even before this accident or this death or this unintentional killing. And so that evidence from prior in her care, prior in her parenting, in those prior proceedings, also goes to inform how she was caring, if she was caring for this child at the date and time of her death. Ordinarily, we think about a criminal incident in a box. We think about the very specific time, place, and act that occurred that gives rise to a certain claim or an action or a charge. But in this case, since there are other instances that might inform what led to this accident or this unintentional killing or the death of this child, those prior incidents might be very telling in revealing the full story and the full circumstance of this child's conditions.
Do you think she's got to testify at a trial and explain her behavior? I mean, again, taking these allegations as true and taking her statements as true, she doesn't jump in the pool or has trouble recovering her daughter because she can't swim. You know, their parents probably going to be on that jury who would be like, I don't care. You know, like, you should have done whatever you needed to do to try to help your daughter.
I absolutely hear you. I absolutely agree with you. As a parent myself, that was one of the first facts that jumped out at me. And I think that you're right that there would be an inclination on the part of a juror to say, are you kidding me? You throw yourself in front of a train. You do whatever you have to do to help or to save your child. I have to harken back, though, that I think when and if a jury is impaneled in this case, they would have to take their oath very, very seriously to abide by the instructions of the court and keep an open mind and not jump to conclusions and not find any evidence before they are properly charged. And remember, again, there is absolutely no burden on the defense either to present a case, to present a theory of the case, or certainly for the defendant to testify. She has a Fifth Amendment right to maintain her silence. And the jury will be instructed that they cannot hold it against her if she chooses to exercise that right to silence. So according to their charge, according to their instruction, a jury, by taking an oath to be a member of that jury, they would have to abide by that instruction and not hold it against her. Does that happen in the real world, in real life? I sure hope so, because if it doesn't, then we're calling into question the validity of our entire jury system.
Before I let you go, real quick, Dr. Gupta remains jailed in Miami-Dade without bond. Her legal team, though, is seeking pretrial release. A hearing on that issue, it's expected to take place on Monday. What do you think her chances of getting released are now that she's only charged with manslaughter and not murder?
So I think that the downgrade of charges is in her favor. The fact that there is less of a penalty on the horizon for her. I think the fact that she already left the jurisdiction, the fact that she was found hiding, is certainly going to be a prosecution argument, that she is not a reliable presence at trial, that she has already shown a tendency to leave the jurisdiction and not be where she is intended to be. But I think that the fact that she's invested in her own attorney, that is something, believe it or not, that does weigh in her favor. She is showing an investment in her defense and a willingness to fight the case and to answer to the charges. And so that is something that the defense would bode in her favor to release her pretrial.
Professor Marian Braccia, thank you so much for coming on. Appreciate it.
Thanks for having me, Jesse.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.